This is Boomer Time, a proactive podcast for baby boomers, about baby boomers, and for people taking care of baby boomers. If that sounds like you, then you're in the right place. I'm Nancy Kogar, an elder law attorney and aging advocate, and this podcast was made just for you. Remember, though, the things we discuss here are not intended to be legal advice, and no attorney-client relationship is established by this podcast. Hello, everybody. This is Nancy Kogar, and this is Boomer Time. You know, it really is true that what you don't know can hurt you. Being oblivious, and I wouldn't really call it oblivious even, just not taking the time to find out things that are outside of your purview can really hurt you. And I wanted to start with a story today, a story about someone who was very hurt by something that she just didn't realize. It was a couple of years ago. I had a woman who had been married and was very much in love with her husband. She was his second wife. So there were children from the first marriage, 2 stepchildren, a adult boy and an adult woman, not boy, man, I guess. So the husband had 2 children from a previous marriage. And the woman who was his spouse did not have any children at all. He also had a house that he had previously. And so they moved in to what was considered the marital home and had a lovely life until he died unexpectedly. And when he died, he did not have any estate planning. He did not have a will. He did not have, end-of-life directives. But really, in this case, the will would have really made the difference. So what happened was that his estate was governed by the intestate laws of Tennessee, which meant his second wife, and they had only been married a couple of years, would get a 1/3 or child's share. So you know what happens next? Kids moved in. They were appointed as a personal representative of the estate for their father, and they started requiring the woman to separate property, and then required her to sell the marital home because it was in her late husband's name. She was not on the deed. That was a very difficult circumstance, and it could have been avoided if they had sat down with someone who knows about estate planning. So there's just an example, and I like sharing these examples because, like I said, what you don't know can hurt you. Well, today we're going to tackle some of the frequently asked questions, or FAQs, when it comes to estate planning, elder law, and issues involving aging. As you know, I'm an elder law and estate planning attorney. These are questions that I hear often, and some of them may be questions that you have. I encourage you to send me questions because there are a lot of issues that come up, and everyone's circumstances are always different. Even the story I just told you, if your circumstances, the facts were different, even slightly, it may have led to a different result. So this is the second edition of FAQs. You want to go back and listen to the first edition. That was in episode 20. But I hope you benefit from these and let me know what you think. So I'm often asked, what parts of estate planning often go overlooked or may cause problems down the road? And, I'm asked this often on the back end when I have people coming to me after someone passes away and they hand me estate planning that may have been done by someone else years ago. And here's really kind of the typical things I see. Number one, the estate planning just may be too generic. So it's not addressing any kind of special needs or special circumstances. It's just one of those cookie cutter basic documents that really doesn't do much. This is all the time, folks. It's outdated. I know people that have made the effort to have wills done when they have young children, but it's not that uncommon that they don't do anything after the fact. I've had people in their 60s come and they have they have wills from when their kids were, minors. So that's 40 plus years probably. So it's not that uncommon, but it really is problematic. You need to update your estate planning as your needs and your circumstances change. And, they do change over time. Another big issue, which, is something you might not even be aware of, but I see this from time to time. People will go to the effort of establishing a trust, but then unless they're specifically told and instructed by whoever assisted with the drafting or follow up with a financial advisor that understands trusts, those trusts can remain unfunded. So what I mean is, if you've got a trust that's just an empty trust and say your will pours over into your trust, well, congratulations, you're going to have double administration. So you'll have to probate your will, or your heirs will have to probate your will, and then they'll have to have everything pour into your trust and then administer your trust. So I know that's not what you intended when you did this initially, but have it checked out. It's worth it just to sit down. With someone like me for an hour, and I can look at documents and I can talk to you about updates. This is so important, folks. Another issue, the originals. It is very important to maintain the originals, especially the original last will and testament. So if those are not maintained or just simply lost along the way, which can happen, so that when you die, you don't have they can't find the original will, or you become incapacitated and they can't find the original power of attorney, that is going to be a big problem. Number one, because there's a presumption under Tennessee law that if you do not have the original, the law presumes that you revoked your will. So your heirs are going to have to overcome that presumption, and it requires filing a separate legal action to prove that you didn't revoke it, so that a copy can be probated as if it were the original. So that leads me to the next question. How often should I have follow-up or have my estate planning reviewed? Well, there's a general acceptance that you should have it done every 5 years, at least every 5 years. But I always tell people, I want to know if your circumstances change. You had a new grandchild, you had someone pass away, you're moving, you're diagnosed with a chronic illness. I want to know. I don't want to find out later, because there's probably things we could do. Maybe there's a change in the law. That happens from time to time. Or maybe you move to a different state. That's a time when you want to look at your estate planning. Sometimes I have, surviving spouses that come to me and they say, my spouse died and we made our estate planning together. Do I need to probate their estate? Well, I usually tell them it depends. So remember that story I told you when we started? That was a second marriage and there were separate assets. So there was a required probate there. But you really need to sit down and look at the titling of assets. If something's joint versus individual, or their beneficiary designations, that can make a big difference and can avoid having to administer an estate on the front end with the first spouse passing away. How is elder law different than general law practice? That's a good question. Elder law really has an emphasis on issues that impact aging. If you spend some time with me, you can see that, right? I spend a lot of time talking to folks about long-term care planning, just quality of life planning, Medicaid issues, TennCare. If you have a chronic illness and there's a circumstance that you may end up in a nursing home, asset management, capacity issues, and even the protection of rights for vulnerable adults, including elder abuse and scams. I've talked about scams. They happen all the time. So that's just a few initial questions. A lot of information there, huh? Well, we're going to take a quick break, and when we come back, I've got some more for you that I think are going to be helpful. So stick with me. I'll be right back. Hey everybody, this is Nancy Kogar, and this is Boomer Time. Hey, don't forget, I want to buy coffee for you. I think coffee is a great way to have some of these conversations, sit down and talk about some of these things. Don't you want coffee on me from Scooters? This is the last week, and we're going to be picking winners. So register to win, and I'm going to have multiple winners. So I'd like to buy coffee for you. We're talking about FAQs, frequently asked questions, when it comes to estate planning and elder law. Number 5, can I plan for a disabled or dependent child as part of my estate plan? Yes, absolutely, and I recommend that, but you actually have to plan. And not planning for that can lead to serious issues. You need to take the steps to look at special estate planning provisions, things like special needs trusts, specific provisions or other types of trust with trustee oversight for assets. There are even trusts within your will called testamentary trusts, and some people even disinherit their children to protect their eligibility. And there's a lot of options there. Best thing is to reach out. Number 6, my mother has been diagnosed with dementia. Can she still make estate planning documents? Maybe. I would say don't delay, but we need to get proof of her capacity. You have to have the requisite capacity to make these documents in Tennessee. And, that's different than general capacity. Testamentary capacity is what they look at. And in Tennessee, that is assessed based on the testator, the will maker's mental ability to understand the act of making a will, the nature of their estate or what they have to give away to their heirs, and the implication of those decisions regarding the disposition of their property. And that all needs to be proved at the time the will is executed. I will tell you that if there's ever a question about this is the kind of stuff that's ripe for litigation. So if this kind of thing comes up, I am always making sure that we discuss it on the front end. And there's some things we can do, but don't try to do it on your own. I'm telling you, you need some extra help with this one. Number 7, can a power of attorney provide specific provisions as to dementia-related issues? Yes, and in fact, they should. Before you make a power of attorney, though, you also need that requisite capacity, but it's a little bit different than the requirement for a last will and testament. Capacity required for a power of attorney in Tennessee is similar to that's required to enter into a contract, because you're giving someone the authority to make decisions for you. So it's distinct from that capacity required for a will. In contrast, capacity to execute a power of attorney requires the understanding of the nature, extent, character, and effect of the transactions which are included in that power of attorney. It's important because you could give someone the power to sell your home, to change your bank, move your assets, all those kinds of things. So that just makes sense, doesn't it? That, you need to be able to be in your right mind if you're going to give someone the authority to do that. And you also need to make sure it's someone that you can trust. And that person is going to be a fiduciary for you, which means they owe you a duty of faithfulness, and a lot of other things come with that. Number 8, I hear this a lot. I think I just need a simple will. Do I need anything else? So yes, you need a will. You need powers of attorney, both healthcare powers of attorney and general or financial. If you don't believe me about that, go back and listen to episode 10. I termed that one, You Are SOL Without a POA. I think that will be helpful for you to listen to that. You also need end-of-life directives. Man, this stuff is important, guys. You have a constitutional right to make decisions about your health care. But if you are not conscious and there's no one with the authority to make those decisions, the default's just going to be to keep you alive. Okay. Funeral arrangements, final disposition of remains, and trusts. When you make an estate plan, you really need to have a healthy discussion about trusts. They can be very beneficial, and you don't need to be Leona Helmsley to have a trust. They're an effective tool that I think can, depending on your circumstances, can really help you on the front end and the back end. 9, what is the greatest threat to my financial security in my later years? Okay, so you've spent your better part of your life, accruing assets. Now you want to protect them and have them, in your later years. What is the greatest threat? Well, long-term care costs and recovery. And with that, not planning. So according to the National Council on Aging, 80%, folks, of people who are 60 years or older, and that means 47 million Americans, okay, do not have the financial resources to cover long-term care services. 11 million Americans have absolutely no assets to draw from when they get to that stage. 1 in 7 will require care for more than a 5-year period. This is what I talk about when I talk about the graying tsunami and the aging of America. There is going to be a great pressure that we're going to continue to see as people age out. And you need to plan. Please plan. This is a snowballing crisis. I've talked about it before. The cost of care is going up. It's harder to get care, harder to find space in assisted living facilities and so forth. You need to have a plan in place. And I want to try to help you to have the right plan in place and be able to stay at home if you can. Number 10, what should I do with my original estate planning documents? This one comes up all the time, folks, believe it or not. Put them somewhere where they are protected and can be found. Okay, so the default, of course, is safe deposit box at the bank. But do you know that can lead to a ton of problems? Here's the problem. Access to an individual safe deposit box is essentially sealed off when someone dies, just like bank accounts. And in most states, including here in Tennessee, the executor must present court-approved documents, certified letters testamentary or letters of administration if there is no will, to the bank where the box is located in order to gain access to that box. So that's like putting the cart before the horse, really, right? How are you going to get the will if you've got to go to court first? That's a tough one. And I do see that come up quite a bit. It causes a lot of stress. So there's some alternatives. You can have a safe at home. Make sure it's a fireproof safe. And, in this instance, I know I caution against adding people to your bank accounts, but it might be a good idea to add a kid to your safe deposit account, because then they'll be an owner and they can get access even when you pass away. But make sure it's a child you trust. I am going to take another break because I know this is a lot of information, but I hope it's helpful to you. And if you hear something, but you want to know more about it, best thing you can do is reach out. You can reach out. You can find me at nancykogar.com. And I'm glad to talk with you. So I am going to take another quick breather. And when we come back, we'll talk about a couple other issues, and then we'll wrap things up for this episode of Boomer Time. Okay, be right back. Another question I get from folks is, how do I protect my house from TennCare recovery? This is a real concern for a lot of people, legitimate concern, because as you may or may not know, if you receive benefits, if you're eligible for benefits, first of all, and you receive benefits from TennCare, which is essentially Medicaid here in the state of Tennessee, they have a mandate from the federal government to recover for anything that is paid out on your behalf. So what that means is when you die, there's a report that will come out and it'll say, for example, John Doe received $75,000 worth of TennCare benefits before his death. So as far as that $75,000 is concerned, TennCare has a mandate from the federal government to try to recover those funds. So that's what recovery is all about. That really wasn't the question, but I think that's important to, clarify that. So how do you protect your house from TennCare recovery? Well, it's complicated, and a lot of it has to do with timing. But I can tell you a couple things not to do, okay? Do not quit claim your house to your kids. Don't do it. That is considered a fraudulent transfer. You are transferring away what is probably your biggest asset. It's probably worth a couple $100,000, and you're giving it away for nothing to your kids. Don't do it. The state can set that aside, and it can make you ineligible for benefits. So just don't do it, okay? There are other things you can do with trusts, and also titling is important. Depends on the titling on the property, but you need to sit down with an expert, an elder law and estate planning attorney like me, and we can go over some of that. And as I said, you have to be eligible in the first place, so that's a whole nother issue. And, when I do planning, I want you to plan so that you're not planning towards nursing home care. You're planning to avoid nursing home care. I want you to be able to have a high quality of life and have options to stay at home and not go to a nursing home. So I think that's a much better option. Most people agree with me too. So as I mentioned, a word about TennCare recovery itself. It is mandated by the federal government. Every state administers it differently. We got Georgia to the south of us. I am not licensed to practice in Georgia, but they have their own Medicaid program, and they are also mandated, just like Tennessee, to recover. Interestingly enough, your house, for purposes of eligibility, is exempt, okay? So it doesn't account against whether you're eligible or not. It's just on the back end that it's the problem. But eligibility really is based on your income level. And that recovery will not occur until the second spouse dies. So that's important too. Like I said, I'm going to do a whole episode, maybe more than one episode on all this, because this is very complicated and bureaucratic because it's a government thing. But, the law changed recently, and now TennCare has a limit of 1 year to recover. But they need to have proof of notice that the individual who received those benefits died. That's important. And they can only recover, they have limited recovery here, so they can only recover in probate. That's important too. More on that in another episode though. Okay. What will be included in my estate? Well, generally speaking, both your assets and your liabilities. So what you have and what you owe when you die. Joint assets won't be part of that. Joint assets pass automatically by operation of law to the other surviving owner. And beneficiary designations, things like that, life insurance contracts, payable on death accounts, all of those pass automatically. So if it's something you're holding in your hands individually, then chances are it's going to have to be probated and be included in your estate. So, interestingly enough, I wanted to mention that, and this is a total aside, but, that can include a business interest. I think that's a huge overlooked issue. If you don't have a plan for your business, and so many people are small business owners, that can really foul things up. And as a matter of fact, here in Hamilton County, the chancellor, who's in part 2 over probates and so forth, has moved to appoint a receiver who will review cases that involve a business interest. And sometimes, if there's not enough support in place, that receiver will get appointed to continue the business or wind it up. So this is an important conversation you need to have I just wanted, for some reason, I thought about that and wanted to point that out. All right, moving on. What are the key differences between a will and a trust? That's a good question. So, a will is a document that must meet certain statutory formalities. It has to look a certain way under the law. There's a requirement for that. You might want to listen to my Don't Do It Yourself Wills Lead to Disaster. That's episode 7. There's some real interesting things that may caution you, hopefully, if you listen to that one. A will is signed, witnessed, and notarized while you're alive, of course, and we already talked about you have to have capacity, but it is not effective until you die. And with that, it can be revoked up to your death, as long as you have capacity. Likewise, wills have to be probated in court. Wills in probate are subject to creditors. Wills in probate can take up to 1 year, so there's no immediate access to assets oftentimes. Trusts, in the meantime, trusts can be specific for specific needs and purposes. They can be revocable or irrevocable. They can take effect immediately upon execution, and they can have different stages in them. There's no court direction necessary. Assets can be accessed immediately, and transfers can be done seamlessly as provided by the trust document. I know that's a lot, but that's a conversation, I like to have with folks to talk about options. So what happens if I die and my heirs cannot find my original will and they only have a copy? I kind of touched on this earlier, I think, but there's a presumption under Tennessee law, if you don't have the original, that you revoked it, okay? So that's going to require you to file an action to determine, or your heirs to determine, that the will was lost and that the court will allow you to probate a copy of it. I've done this before. It's not easy, and of course it leads to an additional expense because it's a legal action. But, if you want that will probated and you don't have the original, it's a requirement. So what I would say is make sure that you have that original, and we know where to find it. So in, the most rare circumstances, not really rare, but in extreme circumstances, there's a possibility that your estate may be forced to be administered intestate, even if you had a will and we don't have the original, just like there was no will. So that's not good either, right? Whew. Boy, I told you this stuff is complicated, isn't it? I hope you're benefiting from this. Let me know. I like to take intentional time to share these things with you because I care and I want to educate you more about how complex these things are and how you really should take some time to plan. I don't want you to get stuck on the back end and not be prepared. So if any of you have a specific question or an issue that you'd like us to discuss, feel free to reach out to me, okay, at nancykogar.com and let me know, and we can answer that on an upcoming podcast. And, I love resources, so there are lots of resources on my website, too. If you've got a need to do some planning, you can also reach out to me and schedule some of that. There's more information at the website, nancykogar.com. And also, remember to subscribe to our newsletter, Elder Law News You Can Use. I hand select those articles because I know that they are relevant and important. And that's monthly, so that come right to your email box. And as far as the podcast, share it with a friend, follow it, let me know what you think. The podcast is available on my website and Apple Podcast, Spotify, and guess what? Now we're on YouTube. Isn't that exciting? Check it out. I'm so excited about that. And you can also follow us on Instagram, Facebook, and as I mentioned, please share it with a friend. Lastly, before I share some encouragement, don't forget to sign up, register to win a cup of coffee on me, okay? I know it's Scooter's coffee, so it's good. And I think coffee leads to the best conversations. And I want you to be able to sit down with your loved ones with a cup of coffee, good cup of coffee, and have these conversations. Okay, well, We need some encouragement today. I feel it. So, it's not easy getting older. I feel it. I was walking around earlier today. My legs were killing me. But it's because I was working out with my trainer, and I didn't see him for a couple of weeks, so he really worked me hard. But, you got to keep those muscles going. And I've even talked about that on the podcast. But please know that if, you're not feeling well and you're aging, and maybe that's leading to some distress, please know that, as I say, I'm a person of faith, and God still cares for you. He knows every single hair on your head, gray or not. So, and I want you to know I care about you. So that's the reason I'm doing this podcast. I want you to grow more gracefully. So keep listening, and let me know if there's something specific you want me to talk about. That's it for today, and I hope you have a wonderful week, and I will see you next time. By the way, this is the 30th episode. How about that, folks? We're chugging along, so I'm glad you're chugging along with me. I'll see you next time, okay? Bye-bye.